So morning, everyone. So the first question is, well, what's an investigation? And this is from the ACAS guide. And the most important words are fact-finding exercise. This is to distinguish it really from a disciplinary hearing. If you're doing the investigation, you're not the decision maker. You're gathering and providing the evidence to someone else to make a decision. So the leading case on this is from a 1978 case, Birchall Home Stores and Birchall. British Home Stores and Birchall. You'll see that there's a reference to carry out as much investigation as was reasonable, and I'll have a look at what reasonable means shortly. But the ACAS code and the ACAS guides are worth reading, but any modern, well-drafted disciplinary procedure will incorporate the key points of the ACAS code. It's also worth remembering the key stages. They should be done by ideally 3 different people. So the 3 stages are an investigation, sorry, then the hearing, and obviously the outcome flows from the hearing and the appeal. So ideally, these should be done by 3 different people and in ascending seniority, ideally. So I'll have a look, we'll come on to look at the reasons for that shortly, but it's worth remembering, again, the separation of roles. You as the investigator are just doing the fact finding. You're not doing the hearing. You're not arriving at any outcome. Is it acceptable to have the same HR lead throughout the process? That's a very good question. I was 20 years as an over 20 years as an employment lawyer, and I used to act for lots of employers in tribunal doing the advocacy. And I remember one case where one of the reasons the case we lost, we came second, was because the same HR person was involved in the whole process. She advised at the investigation stage. I think she did the investigation. She then advised the panel, was on the panel, the disciplinary, and at the appeal. The issue there was she really didn't like the person who that was being investigated and was the subject of the disciplinary. And that was one of the main reasons that we lost. So I would say ideally, to remove any risk of allegations of bias, ideally you would want to have more than one HR person involved at the different stages.
And I suppose, Simon, one of the reasons we often get instructed to carry out investigations is to help solve that problem. Because if you, as your HR role, are carrying out the investigation, it's then very difficult for you to provide impartial support throughout the rest of the process.
So the role of investigating officer, gathering evidence, I've mentioned this a few times already. We'll have a look at the different sorts of evidence that you should be looking for. So fact finding, if there's a conflict, ideally when you come to prepare your report of, I do find it's more likely than not that there was a, so my connection is unstable. It was more likely than not that there was a meeting or there was a discussion on this date, and it is also appears to be likely from the evidence that this manager did say those words. That's the thing, and that's the extent of what your role is. And then the final bit is recommendations. Sometimes, well, investigations, we're asked to do that. Other times we're not. The main recommendation we're usually asked to make, if we're doing a disciplinary investigation, is there sufficient evidence to mean that this should go forward as a disciplinary matter? If we make that recommendation, that's the extent of it. We don't then go on to consider what the level of sanction should be. The other recommendations we do make sometimes are things we've noticed along the way. We might have noticed there's been a lack of training on certain areas, or we might want to recommend that certain people engage in mediation because they clearly don't get on and there's a breakdown in workplace relationships. Sorry, Kenny, there was a question I saw flash up and I didn't get a chance to.
It's sort of similar themes, really, I think. So the first question is, what if your HR department is very small and so you don't have 3 different people to manage the 3 different stages? Very common scenario which comes up. And the other question, slightly different, but what if you've got a line manager chairing the hearing, but the manager has provided a witness statement as part of the investigation. Can they do that?
Ideally, I mean, I think if because of circumstances and if you can't get anyone else in to assist, then I think you want to do kind of as little as possible and just make sure that you are clearly seen just to be advising on procedure, that you're not get involved too much in decision making and you're not asking too many questions, you don't attend and you don't effectively find yourself running these meetings, that you make sure that the managers involved are doing the work and are clearly seen to be doing the work.
And I think we would ideally advise that you wouldn't have somebody who's been a witness.
Yes,
who would then be hearing the matter. So if you know, and I think part of this, and I know Simon will talk about this, is your really early stage planning when you're getting into a process like this, about thinking who might do what. We've had one other question come in. So if the HR support is not involved in the investigation, would it be okay for them to be providing support at a hearing and then an appeal hearing?
Ideally, you have different people doing different roles. But yes, I think if they've not done the investigation, and I actually don't think it's a good idea for HR to do these investigations. I think we do lots of training for managers on how to carry out investigations, and that's ideally what you want. You want HR there providing support about how to do it, or advising on process, but really you want managers doing these investigations. That might be controversial, but that's certainly our view, and certainly view of a lot of our clients who we do the training for. So yeah, it's.
And so I think then if you haven't done the investigation, and many people do have a small HR team, then I think you can have the same HR person providing the HR support at a hearing and at an appeal hearing if you need to.
There was the infamous case, I think it's called RuPaul case, where the reason the company lost in the tribunal was that the HR manager persuaded the manager here in the hearing to change his mind. The manager thought this is worthy of a final warning, and the HR manager then persuaded the manager to turn it into a gross misconduct finding, and that meant it was an unfair dismissal because it wasn't the decision maker's decision. He was effectively talked into it. So again, it's about sort of staying in your lane with when you're in HR and just advising on process and not doing any steering. We've already touched on some of this. So you need someone with the right skills, experience, and perspective when you're appointing the investigator, and they're unconflicted. So you don't want someone ideally who's been a witness or is involved in this. So you certainly don't want, let's say that you're investigating agreements about a line manager, you don't want the line manager carrying out the investigation. Also the right skills and perspective. If quite often we find ourselves investigating senior people in organizations, we do lots of work for schools. So at the moment, I've got at least 2 investigations. I've just finished one. I've got doing another one, investigating the senior HR person and an executive principal of a school. So it would be very difficult for someone relatively junior in that school, for example, to carry out that investigation. And unconflicted, I've already mentioned that. So does the investigation have to be trained? No, you don't have to be trained, but it's a good idea to be trained because there's a lot to think about, and we do provide training. So then the next point is I did a similar seminar to this with Gareth Edwards, who's the partner at VWV, and he made a point about internal and external and independent. The point he was making is, if you decide to bring someone else in, an outside organization, we do approach it as to be independent, but sometimes you get challenge on that because people will say, well, who's paying you, who are paying you? And the point Gareth is making is it's probably more correct to describe the person you're bringing in as external, but we approach it independently, and we certainly come with a blank sheet of paper, and we're not looking to find any particular outcome. But the point Gareth was making is that it's probably more accurate to describe them as external investigators. So separation of roles. So why would you want a separation of roles and different people to carry out the investigation and disciplinary hearing? Well, if you've got, let's say someone's carry out an investigation and then they pass it to the next level up. What you want for the person carrying out that disciplinary, for example, is for them to look at the investigation with a fresh pair of eyes and say, actually, is there sufficient evidence here to justify going forward to a disciplinary hearing, or is there sufficient evidence, or am I prepared to overturn what's been recommended in the investigation? And similarly, when you get to the appeal level, the question is, am I comfortable with what that decision is that's being made at the disciplinary hearing? Do I believe it's a fair decision on the evidence? And if you're going to overturn a previous decision, you're more likely to do that if you're more senior, or if you're in a completely different bit of the organization, than if it's, say, your manager, you're having to review their decision. So that's why the ACAS guide recommends different people do it, and ideally ascending levels of seniority. So you are prepared, and you've got the sort of gravitas and experience to say, actually, I don't think this is, I think there are flaws in what's being done here. I think we need to start again, or I don't think there's a sufficient case to answer, and I'm prepared to disagree with what's gone on previously. So what makes a good investigating officer? So the first thing is curious. The reason I put curious in, I think the best role model for an investigator is Columbo. The approach you're taking is, help me understand this. Just you explain to me. So when you're investigating, you're saying, help me understand it. Please explain to me what's gone on here. Tell me all about it. Give me all the details. The next thing is about not just willing to take the first answer and being brave about it. Sometimes you might find yourself in quite fraught situations. Let's say you're dealing with someone who's accused of being a bully, and they might become quite aggressive when you start asking them the questions, and they may just give you an answer and then expect you to move on. But you can say, actually, I just want to just pick up on what you've just said there. Let's just go back and just examine this, because someone else said this, your colleague has said this. So it's about going back to it. Sensitivity, quite often you're going to be dealing with quite difficult issues, particularly in bullying cases or harassment cases or discrimination cases. It's important you're sensitive to the subject matter that you're dealing with. Report writing skills. When you get to the end of the investigation, you've compiled a lot, or hopefully you've compiled a lot of evidence, and your job then is to try and distill all of that into a sort of coherent form. So there's often conflicting evidence, so you need to analyze that conflicting evidence. How do I resolve that conflict? What evidence is there to support what this person said? What evidence is there that undermines it? And you reflect all of that evidence. Balance. Now, balance, I would say, is the most important one of all, because what you're not doing as an investigator is you're not building a case against someone. What you're doing is you're investigating a situation. So you're there to find all of the facts in this situation and whether or not that supports the particular employee. So able to proceed without delay. So what this means is that if you're appointed as an investigator, you need to be seen to be getting on with it. Quite often these things are very serious. Someone's job or career may be at stake here. So it's important that you're seen to be treating it as a priority, so it doesn't slip to sort of fifth on your to-do list. It's moves to first on your to-do list. And really, if you're appointed investigator, you need some help, ideally to sort of take some work off you so that you can proceed, you can get on with it, so you can demonstrate you've taken it seriously. Sometimes there are delays, but you've got to try and make sure they're not your delays. Quite often, people go off sick, or people take a while getting their evidence back to you, or getting emails back to you, etc. So there sometimes are delays, but it's important that they're not your delays. And critical evaluator, that's really the point I was making about balance and report writing skills, because it's important that you're seen to be considering all of the evidence, that you're not just skipping through and picking certain bits of evidence out, that you're reflecting all of the evidence and you're giving a balanced report.
Simon, we've got a couple of questions.
Yeah.
The shorter one is about report writing. So is it okay for HR to draft the report, also to draft the hearing or appeal outcome letter, and then for the investigating officer to review this? So the investigating officer, not the original.
No. I would say it needs to be, again, the employment tribunal is going to know what is in your mind when you're drafting this. So if someone else is drafting the report for you, I would say that there's always a difficulty, because they may be putting their own particular slant on it. So I would say you really, it's not the answer you probably want to hear. If you're the manager, you ideally want someone else to draft it for you and you to sign it off. But really, it needs to be you writing this report, because you need to be reflecting all the evidence, because if they haven't heard all the evidence, then it's very difficult for them to write the report.
And I think there are really practical things that HR can do to support with that, like giving managers a really good template report. Structure, reviewing it. It's always really helpful to have somebody to just give it a sense check. Read through it. That's all fine.
Yes, you can do that, but really you need to be the one writing it.
Yeah.
Right.
And then the other question is about a slightly more complicated scenario. So what if the allegations that the investigator is looking at are not substantiated by the evidence, but there is evidence of other conduct, for example, that is of concern? So this is really around the scope of the investigation.
Yeah, I've deal with that in a bit later on. I've got a slide that deals with that. So let's deal with that then. So the next question is, we touched on this earlier. What's reasonable in the circumstances? What's reasonable in the circumstances? There's two considerations here. The first is, what's the size of your organization? So if you're a corner shop with 2 or 3 employees, then I think an employment tribunal is going to expect you to do a different investigation than probably, let's say, Amazon with lots of HR resources, etc. So that's one consideration. The other one is the nature of the allegation you're investigating, because if you're investigating a bit of lateness, for example, that's probably relatively small beer usually, but compared with sort of theft or fighting or someone turning up drunk, where this could result in potential dismissal, then that's going to require you probably to carry out a much more detailed investigation. And really, the key is it needs to be enough so that if it does proceed as as a disciplinary matter, for example, that the employee, the accused, as it were, can understand what their case is, what the case is they need to answer. So this is when you're planning, if you're doing the investigation, you're planning what to do. So the starting point is the terms of reference. You always need to go back to what the terms of reference. So it's really important that your investigation starts properly. You shouldn't really be involved if you're the investigation officer doing the terms of reference. It's a bit like marking your own homework. So ideally, you will have someone who commissions the investigation, and they need to set up the terms of reference, and they need to set up what the key questions are, what the key points are that you need to address. So your questions always need to be based on the terms of reference. And I think this also touches on a point we've seen a couple of times where people doing investigations just invite employees to just submit statements. And you can end up with a bit of a lottery with that, because the employee the statement may not touch on the key issues that you want it to address. So we would always recommend against just getting the employee to draft their own statements. The investigating officer should be asking the questions, and from the interview notes are then effectively the statement. So you know what you're investigating, and you're asking the questions around what you're investigating. Ideally, you want to arrange for a note taker to be there, because I've done both sides. I've done it doing my own notes, and I have a note taker there, and it's much better to have a note taker there, because you can be thinking about the evidence that you're hearing and the next questions and any potential conflicts, and so it means you're able to sort of look around more and think more about the evidence you're hearing, rather than just concentrating on making sure you're taking an accurate note. And just reminder, the meeting needs to be confined to establishing the facts. You're not there to establish guilt. You are just there to obtain the evidence. So next slide, please.
We've got just one quick question that's come in here, Simon, which is about what happens if misconduct is admitted at the investigation stage? Do you have to still proceed with the whole disciplinary process?
Well, I would say yes. I mean, certainly you would want to make sure that's fully recorded. And yes, because you're not the decision maker, you've always got to be careful not to sort of inadvertently segue into carrying out a sort of a mini disciplinary. So you just take a note of that, because it's you're not making decisions on that. So yes, you've got to be careful not to stray into that.
And I think that's right. I think what it does mean is you may not carry out quite the lengthy investigation that you would have done otherwise if somebody has admitted their misconduct.
I'd suggest you still need to do an investigation report, but obviously you'll be recording that.
Yeah, absolutely. And we've got a couple of other practical questions. So thoughts on recording of the meeting with the consent of all present, or for example, Zoom recording. This comes up now very regularly.
I think not. I would think having a note taker is much better. Transcripts of recordings are really bitty. People interrupt each other. Much better to get a good note taker there. And
Agreed.
Trawling through hours of notes, so hours of recordings, you end up filling up your hard drive. And it's there's the GDPR issues. We don't record them. We do it. The note we do isn't verbatim. It's a summary. It's supposed to be an accurate summary, and we will send those notes to the person we've interviewed afterwards to check that they're happy with them and to make any amendments to them.
And it does come up. People sometimes are fairly insistent about recording, and from time to time we might agree. I think the consent point is really important. What you don't want is one of the parties recording it without the consent of the others. And then we've just got a quick question about can HR be there as the note taker if they are the HR person guiding the process?
I think so. If you're just silent note taker, that's fine. That's fine. So questioning techniques. Quite often we find when we do these investigations, someone turns up with a prepared statement. And so the question is, do you need to probe further? Yes, you do. You need to make sure that the questions you've planned out are all addressed. And so you might have to say, like, apology, you've already touched on this, but I just want to drill down into these couple of points. Any inconsistencies you need to ask them about. You need to approach these investigations with a healthy degree of skepticism, I would say, and you need to make sure that you are mindful that someone may lie to you in this. One or more people may lie to you or give you inconsistent evidence. So you need to be alive to that. It's also worth remembering that when you're doing investigations, you don't just get one go at this. If you carry out an investigation interview and then you interview 2 or 3 other people, things might come up in those subsequent interviews that you might need to re-interview that person about. So you don't need to worry, you need to get it all done in one. Ideally, you want to make sure you get as much done in that first interview, but sometimes you'll need to go back and ask for further interview and or send some follow-up clarification questions. So you don't just get one go at it. Plan out the questions you want to ask. It's really important to do this because you don't necessarily have to script it out word for word, but you need to make sure that you know what you want to address in that meeting, particularly if they're accompanied, let's say, by a union rep, and you find yourself, the union reps, raising lots of different points, let's say trying to raise a grievance in the investigation, etc., and throwing quite a lot at you. It's quite possible to sort of lose your way a bit. So if you've planned out the questions you want to ask, then at least you can return to those and you say, I know I've got 6 questions. I asked the first 2, and then we got slightly sidetracked, and now I'm back on question 3. So really important that you've planned that out beforehand. You don't just go in with a blank sheet of paper. So next slide, please.
Sorry, Simon, just very quickly on that one. Can the follow-up be done in writing rather than in another meeting?
Yes, and that we often do that. Anonymous, I'm going to touch on that one. I've got a slide on that. Yes. Right. So now we're going to get you to do a bit of thinking. So we've got a poll on the next slide. So move on to the next one. So you're the investigation officer. You've arranged to interview Joe. Before the meeting, Joe emails you to say she finds the process stressful. Can her husband come along with her? What should you do? So if you want to vote now, then we'll have a look at the answers. How many have we is everyone? I think we seem to have paused there. So the majority have gone with can we close that poll? So we've got 92% went for C. I don't think there's actually a right answer here. The answer is it depends on your organization's approach. The starting point, there's no right to be accompanied at an investigation. There's no legal right to be accompanied at an investigation, but some organizations do allow people to be accompanied in their disciplinary grievance process. Others have a custom and practice approach. Others say under no circumstances. I used to work for lots of newspaper companies, and because they got a bad history with trade unions, and they were doing their best to keep the trade unions out, they were always mindful of the fact that allowing anyone into meetings that didn't necessarily have to be let into could potentially lead to drumming up union membership. And so they had an absolute rule: no one is ever allowed to be accompanied at an investigation meeting. We only allow you to do what you're allowed to do. Acted for lots of public sector employers, and they always allow employees to be accompanied at investigation stages. So I think the answer is you need to check whether they can be accompanied. What we tend to find most clients do is they tend to take these things on a case-by-case basis. So again, first point of call is what's in your own what's in your own disciplinary process. And then if, let's say, you've got someone who is suffering from stress because of alleged bullying, you might allow that person's husband to accompany you. You probably want to check they're not a solicitor or a barrister, because that can lead to its own problems. But certainly most employers tend to take these things on a case-by-case basis. So reluctant witnesses or refusals to meet. So this often happens, particularly when we're investigating bullying allegations, and also linked to that, confidentiality, anonymity requests. The problem with anonymous evidence is that, well, the first thing is, can it really be truly anonymous? If you're dealing with, dealing with one situation at the moment, it's two executive heads, and one is claiming things that have been said by the other one. Now, so it's going to be completely obvious who's talking about it, because there's only two of them. So there's one complaining about the other one. So there's no point. That can't be done anonymously. And often what you find is, if you do try and make evidence anonymous, then you have to strip out so much of the detail, it renders it meaningless because it's so vague, and it allows the person who's accused to say, well, I don't know what the case is I'm actually answering here. I don't really know what's been alleged. And also you can then say, again, if you're the accused, and you say, well, someone's just made this up and they're doing it maliciously and they're hiding behind anonymity. So we would always recommend it's much better to reassure and encourage that person to give named evidence. And so we tend to, this happens quite a lot in our investigations, we'll end up contacting usually the person who's instructing us to provide someone quite senior who will then get in contact with that witness and provide reassurance and say, look, we appreciate you taking part in this, and if you are concerned about any potential repercussions, then come back to us. So the next one is parallel investigations, so the police and or LADO. So the sort of nightmare scenario, we would say, for employers with the police involvement is, if the police get involved at an early stage, they often say, right, don't do anything else. We will carry out our own investigations and potentially a court case. Now, this can go on for years. And so the only option then for the employer is to suspend that employee on full pay for potentially years. And the thing to remember is, as an investigator, you're not investigating whether someone's broken the law. You're not the police. You're not bound by any criminal codes. What you're looking at is whether, on the balance of probabilities, not beyond reasonable doubt, the police look at things beyond reasonable doubt. You're looking on the balance of probabilities. Has this person breached our own internal rules, our own conduct rules, usually our disciplinary rules, our safeguarding procedures, etc. So you're asking a different question. So ideally, you would want to get on with these things and notify the police afterwards, if possible, because trying to avoid that scenario of finding yourself paying someone for years to be suspended. The other one is LADO investigations. Any safeguarding issues, I think you're required to notify the local authority designated officer within 24 hours, and they then tend to do one of two things. They either take that investigation on themselves, or they will pass it back to the school but keep a watching brief, and they will want to be kept fully appraised of developments. So in that case, I've certainly done several investigations where the LADO is involved, but they just want to be kept abreast of what's happening. So next slide, please. So information gathering, this is a useful reminder. It's not just carrying out interviews that your role is. You are obviously considering any written statements and documents that they provide, as well as the interviews. Often they do provide evidence, but also, and I find often more telling, are the contemporaneous notes, because I'll be interviewing someone about a meeting that happened 6 months ago, and they'll say, well, I did send an email straight after that meeting where I set out my thoughts. I was really upset by what happened. So that is really useful. That's contemporaneous evidence. Or there's a note, a handwritten note that they took following the meeting because they were concerned about what had been said. And again, I'll want to see that. And that's very useful, because that's written at the time. It's not someone trying to recall something 6 months later. That is evidence at the time. The other thing is CCTV is quite useful if you're, for instance, investigating whether someone was in a room at a time or a fight, then you want to make sure, if there's CCTV, that you get hold of that. And it's important to do that at an early stage, because I've certainly found in the past that CCTV gets recorded over. Sometimes they have it on like a 28-day loop, and so it gets recorded over or deleted after a period. So you need to make sure that you get hold of that. And if you're investigating any potential misconduct, if someone's been making inappropriate use of the emails or the internet at work, then you need to make sure that usually you need to coordinate this. So if you are talking to the person accused, you probably need to sort of get them off their computer and then get IT onto it to take a record of what's been done, so they can't delete everything. So you need to make sure you've got the internet access, and ideally take screenshots, again, in case there's a risk of it all getting deleted. I acted when I was an employment lawyer, probably the biggest tribunal I was ever involved with. It was a household name German company, and they had a very strict data protection rule where all emails were deleted after 6 months. Their IT system wiped everything as soon as they were 6 months old. And it was a nightmare, because the case I was involved in, the allegations went back 4 or 5 years. And so it was important to make sure that things get screenshotted and preserved somewhere, because you don't want to find yourself with big holes in your evidence. So, right, so you've gathered all the evidence. What do you do next? Well, you're then on to writing the report. You need to consider and reflect all the evidence, and I've put it the all. That's really important. That it's just a reminder. You are not building a case against an employee. Sometimes as an investigation officer, you can find yourself under pressure because the person instructing you might have a very clear view about what they want the outcome to look like. But your role as an investigation officer, and certainly if this ever gets to an employment tribunal, they want to see that you carried out an even-handed investigation. So you're not just looking for things to support a particular case, because it might be that you find things that support the employee's case, the lack of training, or the fact that several other people have done something very similar. So it's important that you reflect all of that. The next thing is consider which allegations, if any, should be dealt with as a disciplinary matter. And is there sufficient evidence for each one of them? Because I did a panel support a few months ago, and the investigation officer had investigated 30 allegations, and he just said, "Oh, they should all go forward as disciplinary matter." But it became very clear very quickly in the in the disciplinary hearing that actually there was, I think, well over half there was just no evidence for. And so I think he thought I'd just put them all in, but that undermined the case, because yes, can the investigating officer state in the report whether the allegations are substantiated or not? What you're doing is you are looking at each allegation and you're saying, is there sufficient evidence to support each allegation? So it might be that out of the allegations you're looking at, 3 or 4 of them, there's just not sufficient evidence, and that shows you're doing a good job. If you're doing that editorial job where you're saying, actually, I've held all these allegations up to the light, I've looked at the evidence, and actually I don't think allegations 3, 6, and 8 there's actually sufficient evidence for, and so that shows that you've considered it. So yes, that is part of your job as the investigation officer. So next slide, please. You need to report promptly. I've already touched on this. You don't need to rush it, but you need to demonstrate it's a priority, that you've treated it seriously. And if there has been a delay, you need to explain the reason for that. And so when we do our reports, we set out the steps that have been taken. And quite often there are delays, unfortunately, and it often comes down to sickness. And I did see there was a question about this earlier. If someone goes off sick, and often they go off with sick with stress during an investigation, you can't force them to take part. Normally, the first step would be to get them seen by an occupational health specialist. Plug for our next session, but you need to get them seen by an occupational health specialist. And the question is this person able to take part in the investigation? Because the point is, it's often more stressful to have the investigation process hanging over them than actually just getting on with it and taking part in it. And you might need to consider adjustments, like, for example, letting a family member attend with them, or sometimes sending some of the questions in advance. But it's better to be getting on with these things. We try as much as we can to avoid delays, and we come up against various sort of roadblocks, and it's important that you're seen to be trying to find a way to progress the investigation. And so is there any adjustments we can make to move this investigation forward? So next slide, please. So when you're writing your report, you confirm the allegations that you investigated, summarize the investigation undertaken, summarize the evidence gathered. So that's all the evidence. So you're not selective. Set out your findings of fact and conclusion. Reach the conclusion on whether there's a case to answer in respect of each one. And then other recommendations, I mentioned that earlier. That it's not just is enough for disciplinary investigation or disciplinary case here. You might also have noticed things along the way, so often quite serious things that you've noticed as part of your investigation, part of your interviews. You append the relevant evidence, and ideally what you will have is your report. You'll paginate the evidence. If you're doing a textbook job, you'll paginate the evidence, and then you'll cross-refer to it. So you'll say on page 25 of the documents bundle, we tend to have two different evidence bundles, we call them. So one is the interview notes, and the other one is the documents you've gathered. So you will cross-refer. You say, they said this in the interview, but actually this was inconsistent with page 25, which is the email that was sent just after at the time. Never consider the level of sanctions. So you must never put in there, oh, and by the way, I think this is probably worthy of a final written warning. The reason you don't do that is it's straying outside your lane, but more importantly, if you're tying the hands of the person hearing the disciplinary, because the person hearing the disciplinary then can't really make their own conclusion, because the investigator has already given a very clear view. So it's important that you don't give a view about any level of sanction when you're making your decision. So next slide, please. Next case study. So subject of Joe's grievance is her manager, John. So 115. Sorry, can you recommend it should be? Yes. So the recommendation is that I think there's sufficient evidence here that this be heard at a disciplinary hearing. Full stop. You don't go beyond that. So you can say, yes, I think there's sufficient here that this goes beyond, that this should go to the next stage, but you don't go beyond that. So on the case study, so you carried out the interview with John, and then the following morning you get a very angry 9-page grievance against Joe, saying she's been uncooperative and obstructive and seeking to undermine him for several months. So what should Sam do about that? So on to the next poll. We seem to have paused there. So right, so we can, so I think there is a right answer to this one, and it's A. It comes back to this issue of the terms of reference. You are investigating subject to these terms of reference. So terms of reference set out what you're supposed to be investigating. So it's not your call whether you investigate that or not. This is a new piece of evidence. It wasn't referred to in the terms of reference because it hadn't happened. So you should go back to the person who's instructed you. They're often called the commissioning officer. So you go back to them and say, what do you want me to do about this? Is this something you want me to deal with as part of this investigation, or what are you going to do about it? And different organizations will have a different approach. Some might set up a different investigation to deal with that. Some might say, actually, it's so closely related to what you're investigating, we want you to also to deal with it. So it's important that you always go back. If new things occur, that you go back to the person who's instructed you to ask about. And this often happens. One of the last question we always ask in our interviews, which is a good question, but also in a way a bit of a dangerous question, is there anything you want to add or think I should be aware of? And there's been several times when someone said, you need to know about this. This has just happened. Often it's just happened. Like, I've just been in a meeting with this guy, this woman, and they've just done this. And so you then go back to if it's sufficiently serious, then you then go back to the person who's instructed you and said, what do you want me to do about this? So it's important that you remember that you go back and check the terms of reference. The terms of reference, when I'm doing these, I go back to the terms of reference regularly when I'm preparing all the questions. It's at the heart of everything you do.
Simon,
I didn't see that question.
Just for the question that's come in. So in the circumstances where you don't have the luxury of a CO owning because of your company size, would you then make a decision to carry out a separate process?
Well, I guess the question is, who's asked you to carry out this investigation? Someone's asked you to carry this out. So it's the person who's asked you to carry out the investigation you go back to. So let's say it's HR who's asked you. So you go back to the person who's given you the job in the first place, effectively, the investigation job, to go back and ask those questions too. Of what do you want to do about this?
A similar question, I suppose, or on the same theme, is what do you do when the commissioning officer then turns the table on you to ask advice on whether it should be investigated? Whose decision does it then become? Which is not uncommon, I think.
No. I mean, I think it's fine to give a view, and I think it's quite often I find, because this does happen quite regularly, where things get thrown back at it in a formal form, and I'd like to raise a grievance. I tend to take the view: is it related to the questions that I'm asking? And quite often it's effectively a beefed up response to the answer. So you're investigating the grievance. So someone's raised certain questions about this manager, and this manager said that's all lies. I never said any of that. And by the way, this person's a terrible employee. And it's more a continuation of that response. So it would probably be a bit artificial, I find, in those sort of circumstances, to then start a new investigation, because it's related. But it's certainly important to then know that you are then investigating two different but related matters. So you probably would do that.
And that hopefully answers another question that's come in, which is, if you were the commissioning officer in this scenario, what would your advice be? And I suppose there's not a right or wrong answer
No, there isn't. No.
Different ways of doing it. Some people will choose to extend the scope. Some people might say, I'm going to stick with the original scope, but perhaps one of the recommendations might be that there are other things that need to be investigated separately. So there are other ways of doing it as well. Yeah,
because another consideration is quite often timing. If the organisation wants to come to a reasonably prompt conclusion on the first one, the disciplinary allegation, let's say, if then investigating that new grievance, is that going to mean a lengthy delay? Because it might be that they think, actually, we've got sufficient here to make a decision on the original terms of reference, and then we can deal with this one separately. So there's lots of considerations that come into it.
And just quickly, another question around that is basically, do you go back and alter the terms of reference if you then decide you are going to look at things which fall outside the original scope?
Ideally, yes. You'd want something recorded so that when you come to write your report, when you're writing the report, the terms of reference is front and center in it. This is the term that's in the introduction. These are the terms. This is the terms of reference. And then I would say, and it was then amended or updated on this date. So it's important that you track that. So it's important that you're clear about what the terms of reference is.
And we should say this is so common that
yes.
it's a very common thing for the scope to alter slightly as you go through an investigation.
Yeah, and it's also, our experience is investigations really get smaller as we're going through. They tend to expand, and you need to interview these 15 people sort of question. So yes, they tend to expand and things get bolted on as you're going through. So that next slide, please. So any questions? We've already dealt with them as we've gone through, but is there any other ones that have cropped up?
Sorry, Simon and I will stay. We've got one that's come in. Let me just see that one. So if the person who's the subject of the allegation is off sick, unable to attend an investigation meeting, has a summary of the allegation, but wants to be sent the full allegation and witness statements, where do we stand?
No, I would say don't. That it's important with these that you're maintaining confidentiality with this process, and it's important that you keep one eye on that as you're going through this. So certainly, if someone's off sick, I would say, if the only way through, and the occupational health supports this, I would say the only way through is for them to have the written questions. Then you just pull out the relevant bits of the written questions. You pull out the relevant bits of the written questions before, and then you send them to them. But yes, you wouldn't send them all the investigation notes. I wouldn't do that.
No, absolutely. Could we then just go on to the final slides? I'm just saying if there's one more question that's popped up. No,
For reluctant witnesses, there's a potential for disciplinary if they refuse. That's a very good question. I guess it depends on who that witness is. If it's, let's say it's a grievance you're investigating, and the person said, I'd like, X person come along, they're a colleague, they're a junior colleague, and they've seen quite a lot of the things that I've also witnessed. If they're saying, like, I'm really nervous about repercussions, I think to then say, oh, we're going to discipline you if you don't turn up to an interview, that's possibly a bit harsh. But if you've got someone who is the subject of a disciplinary investigation, then yes, I think that's different. If you've got an alleged bullying manager and you're investigating that person, if they say, no, I'm not attending, then that does turn into, I would say you would probably use the disciplinary process or threat of disciplinary process in that circumstance.
And I think with reluctant witnesses, our advice is always to try and work with them.
Yes,
yeah.
Why
are they nervous, and can we do anything to reassure them around the process to get them on board?
More encouraging, less threatening, I would say, generally.
Final question: when interviewing potential witnesses, is there an issue about breaching confidentiality for the accused?
We always talk about the importance of confidentiality when we're doing our interviews. We always say, but what you tell us may be referred to in further conversations, so other people will get to know. We may find it necessary, so it's important that you give that message that they need to keep it confidential, but as part of the investigation, you may need to refer to evidence given by them in further conversations. So certainly, when I'm doing a disciplinary investigation, the person who is the accused, as it were, is always the person I interview last, and so I'm gathering the relevant evidence so I can then put it to them. And it's often important to give named evidence, to say, John said this on this date, said that you said this to them. Can you respond to that? So
and one final one, who do you show the final report to?
Well, as the investigator, you send the report to the person who who's instructed you, and so that's the the HR team. So that's often the extent of our involvement. We send it in, and it's then usually you should take legal advice. Then the question of like who should get the report. It's often, I think, when it goes forward, you might get a summary report get sent to the employee, not necessarily with all the evidence. So yes, that it's but you don't send it to the accused, as it were. You always just send it back to the person who's instructed you.
I think it's always worth bearing in mind what your particular policies and procedures might say. Yeah. Some employers will have it set out quite clearly who gets reports under certain circumstances. Yeah. It's quite common for somebody who raises a grievance to have a copy of the investigation report, and it would always be drafted with that in mind. Yeah. And witnesses need to be told that the person who's raised the grievance would see a copy of their evidence. Yeah. And also have in mind that if it goes on into another process, for example, a disciplinary flows from that, then the person who is accused might get to see a copy of that report. So as the person who's writing it, you need to just have in mind who might get to see this ultimately. Also bear in mind things like subject access requests that mean that people who you might not intend to see the report might ultimately get to see it. So it's important to have that in mind. I think we've had one other question. What's the view on the individual's own line manager conducting a disciplinary meeting?
It really, typical ex-lawyer's answer, it really depends. I mean, it depends on the subject matter of it. Depends if that person is involved or not. It's are they have been accused, but it might be fine for the line managers to do it. Often it's the line manager who will, if they're not involved, you would carry out the investigation, and then it tends to sort of go up through the family tree, as it were. So you get someone at director level, and then and then someone at the director to be held back to do the appeal. Again, people looking at it with a fresh pair of eyes.
We've got a few questions about who's seeing the report. So we always send the investigation in full if it's a disciplinary that's required. Is that correct? And generally speaking, the answer to that would be yes. Where it's a disciplinary, it's really important that the person who's accused of misconduct has got access to all the evidence. So it's difficult for us to answer where it's quite specific queries, but on the face of it, yes, that would be.
I'm doing one at the moment, and I'm also unusually going to be doing the appearing at the disciplinary, and so I think I was asked to investigate about 8 allegations. I gave my views, and I think the school involved have decided to proceed with 4 of them. I think because it was clear that they were the 4 sort of stronger allegations. And so the employee is going to be sent a redacted report with just the 4. So there's no, so they're not, so the disciplinary person will only see the redacted report. They won't have seen the full report. So everyone's working from the same document. So that certainly happens, that if you only decide to proceed on certain allegations, and so you could argue that by sending all of the allegations in, that you that's unfair, because there's other evidence in there. So I've certainly seen that done.
And a final question: how much of the investigation report do you share with the person who's made the allegations where there was no case to answer? And I think the answer to that depends on the way in which those concerns have been raised. If that person has raised a grievance, then again, it would depend on your processes and your policies, but ordinarily that person would get to see a copy of the investigation report. But sometimes you might take a view, depending on the nature of the evidence, as to whether perhaps a summary report is more appropriate under circumstances. So it's always something to be thinking about as you're going through.
And certainly when I did one where, as mentioned earlier, that the equivalent of the sort of John and Joe, I was investigating one grievance that immediately provoked a counter grievance, and I was instructed to investigate both of them. So rather than I then prepared one report, but then I was asked to then prepare 2 summary reports that just dealt with the response to their own individual grievance. So they didn't end up seeing the compendious report, the global one. They just got individual summary reports that just responded to their own grievances. It's important as well, just remember, just when you're doing an investigation to grievance, you shouldn't really use words like, I think this allegation should be upheld. That's going beyond what you're supposed to do. You should say, there seems to be evidence to support this one, full stop. But you don't then, because it's not your role to uphold these grievances. That's the decision maker's role.
Absolutely. So thanks so much for the questions we've had around that. It is quite a complicated area, that bit at the end, in terms of what do you do with that report.
Yes.
And it quite often might need some legal advice around just thinking those steps through. We have had a query about somebody who unfortunately missed the first half of the session due to a technical problem. So yes, the slides and the recording will be shared in a few days' time, so you'll be able to catch up on that. And then just one final point on the last couple of slides is we have developed a series of e-learning sessions along with our colleagues at VWV, focusing on a range of topics, which you'll see on this slide, for your managers, essentially. So these can be purchased and then rolled out in your organisations. They're very short, approximately 10 minutes. There's a little bit of talking in terms of video content, and then there are some practical tasks that people do as they go through the courses. So to give people a little bit of an update or a reminder about those topics. So if you are interested in having a demonstration of those or some information, if you could just let us know by voting now, then one of my colleagues will get in contact and tell you a little bit more about them. They're really helpful, sort of bite-sized sessions, which can be really useful for your line managers if they haven't had a lot of experience in these areas or just need a bit of a refresher.
And I do the investigation one, so it's really good.